Makes sense, not make sense for me, but it makes sense from the attorney. You're
I'm
being
done.
biased.
I'm done. You're not
You're
going to
biased.
interrupt.
This hearing is a perfect example of how courtroom outcomes aren't decided by who's louder. They're decided by who's consistent, credible, and actually answering the judge's questions. From the very first seconds, you can feel the tension, accusations of bias, interruptions, and a judge trying to maintain control of the record. And here's the key. The case itself is a motion to set aside a default judgment. That's not the court retrying the whole dispute. It's the defendant asking the court to undo what already happened because she says the default shouldn't stand. But motions like this are extremely detail-driven. Judges care about deadlines, what was written in the motion, whether the reason matches the paperwork, and whether the request is supported by facts. You're about to see how one phrase, "I was unaware of the hearing," can become the entire case, because once a court finds a statement is false or inconsistent, it undermines everything else. Watch closely. The judge keeps asking for numbers and specifics, while the defendant keeps going broad. That gap is where cases are won or lost.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry,
denied.
I was never trying to interrupt you. You're very
denied,
biased.
Writ may issue. Thank
You're
you.
very
I'm done.
biased and disrespectful.
I'm done.
You're very biased, rude, and disrespectful.
Just mute her and kick her out of the meeting.
All right, quick context so this makes sense. This is a landlord-tenant dispute where a default judgment happened, meaning one side didn't appear or didn't properly respond, and the court entered judgment anyway. Now the defendant is trying to set that aside. Courts can undo defaults, but the person asking has to meet standards, usually showing a valid reason for missing court and acting quickly within required deadlines. That's why the judge immediately asks about the basis. You said you were unaware of the hearing. And notice what happens next. The defendant says she was aware, but couldn't attend because of work out of state and a Zoom request situation. That's a major pivot. In motions, what you file matters because it's the official record. Judges don't love surprises during argument that weren't written in the motion. So from this point, the big issue becomes, is the motion accurate, timely, and supported, or is it a moving target that keeps changing depending on what's being challenged?
State your name.
Here, Morris.
All right. This is your request to set aside the default.
Yes, sir.
All right. And what's the basis? You said you were unaware of the hearing.
No, so I was aware of the hearing. I was available for the first hearing. The attorney's office reached out to me and let me know that the staff needed some to be trained and that they were looking to resolve. So I had to keep reaching out, and nobody reached out to try to come to a resolve. So when the court date did come up, I just couldn't get back in time because I am working a contract with veterans in Las Vegas right now. So that is the reason why that I could not make it. I do believe my Zoom hearing was denied. So that's why I need to file a motion to actually be here.
Okay. Have the funds been paid to the landlord?
So that was the situation for the court date. Just in agreement of what funds they're saying are owed is not accurate.
Okay. I took a judgment was taken in November for $1,571.06. You're saying you don't owe that amount?
Yes, sir. That judgment was the day that I was not there. So we were supposed to try to come to a resolve. The issue actually stemmed from May. And Rachel Dornbush, I did speak with her on the issue in May. She did try to correct some things that we did not come to an agreement. There was a court date scheduled for May 16th, but somehow that was dismissed. But even on the Arborwood's paperwork, they still had down that I had a balance. So we still should have been in court. So that is, I guess they didn't communicate that with their attorney because this is like all the way from May. So this issue has never been taken care of.
Your Honor,
Yes.
I'm looking at the ledger, and the reason that the case was dismissed is because there was a balance. I mean, there was a credit. I mean, there was nothing due and owing. So the case was dismissed for that reason. Your Honor, first and foremost, I mean, I'm going to object to the motion even proceeding because none of that was stated in the motion. The motion says I was unaware of the hearing. If
This
there was
right here
something
is the
more
judge
that
trying to cut through the fog. When a court asks, have the funds been paid? They're trying to see if this is a real dispute over numbers, or if this is non-payment dressed up as confusion. The defendant is arguing the amount claimed isn't accurate, and she's describing ongoing issues dating back months: credits, ledger disputes, rent rate disagreements, and fees. But courts need clean answers: what was ordered, what was paid, and what's still owed. Because here's the reality: ledgers are evidence. If one side claims a balance and the other claims errors, the judge is going to ask for exact figures and how they're calculated. The problem is, if you can't summarize your own math clearly, it becomes harder for the judge to justify reopening a judgment. This is why you'll see the judge repeatedly trying to pin down the dollar amounts. Not the whole story, not the feelings, the numbers.
is verbatim what her motion says. I was unaware of the hearing, and this was only filed beyond 10 days because of the holiday. Well, if she was aware of the hearing, then she could have filed her motion on November 19th, November 20th. She could have filed it long before the holiday occurred, which prevented her allegedly from getting to the court to do it. So I'm going to object, Your Honor, that this motion hearing even moves forward on that basis. And I am going to request actual attorney's fees because the motion that was filed is clearly erroneous and a false statement was made to the court.
I actually did file more than one motion. The motion that I did file for the Zoom hearing, it was actually denied. So I did have to file another motion. And I did speak with two representatives at the court. One of the girls' name was Ashley, and they did let me know that I did have that time to. I actually sent a paper and I took a scan of it, and I sent that in with the explanation of what was going on with the case. So I think you may have read it incorrectly. I can pull it up and I can read it to you now. But the only reason why I was not there is because we were supposed to come to a resolve and no one ever reached out. And Rachel Dornbush, when you're speaking on...
This is the most dangerous moment for the defendant's motion. The attorney is basically saying, Judge, the motion shouldn't even be heard because it contains a false statement. And in court, credibility is currency. The lawyer points to the exact language. The motion says, I was unaware of the hearing, but the defendant just admitted she was aware. That's not a small discrepancy. That's the core justification for setting aside the default. Also notice how the attorney ties it to timing. If she was aware, she could have filed earlier and not blamed the holiday. That matters because courts are strict about deadlines and diligence. And requesting attorney's fees is an extra pressure move, essentially arguing the motion wasted time due to being clearly erroneous. Whether or not the judge awards fees, the bigger problem is this. Once the court believes a motion is inaccurate, the judge becomes less willing to exercise discretion in the moving party's favor.
It was a zero balance. If you check back onto your attorney's documents, onto your client's documents on the ledger, the same day that I spoke with you and you put that credit onto my account and we did not agree on my rental rate, they went back and put a non-sufficient funds fee there. So on the same day, there was definitely a balance and we should have been in court on the 16th. They didn't communicate that with you. My rent was supposed to go up in August. I'm sorry.
There was, and I'm just to try to get the order of this, and I don't know if you've got this, Ms. Dornbush, so what I have is exactly what you stated on the motion. On her request for a Zoom hearing, she just had indicated that she's currently...
When the judge reads the Zoom request out loud, that's not just commentary. That's the judge building the record. The request clearly shows the defendant knew there was a hearing and wanted to attend remotely. That's why the judge calls the unaware of the hearing line patently false. From a legal standpoint, this is devastating. If your motion is built on a statement that conflicts with written evidence, the court doesn't have to guess. It can point to the document. And then the judge gets even more precise. The judgment date, the 10-day window, and the fact there were multiple days before the holiday to file. Judges care about timelines because rules are rules, not vibes. Even if someone has a complicated situation, the court still needs a lawful reason to grant relief. At this point, the defendant's best chance would be clarity, ownership, and exact facts. But you can already feel the judge's patience thinning because the paperwork is
Currently working out
contradicting
of the
the
state of
argument.
Las Vegas. I was hoping to come and resolve, but I have not received a call back yet. I can get a flight after work, but I'd be late for court. Please allow me to appear via Zoom. There's a 3-hour time difference.
And so I believe that was in the Zoom request, Your Honor, that was submitted to the court the day before the hearing on, I think, November 17th at around 3:30 p.m., which was after she contacted our office on the same day. She contacted our office around 3 p.m. and was reminded of the in-person bench trial scheduled for the 18th. But her motion that was filed with the court says, I was unaware of the hearing and it's only after 10 days because of the holiday. That is false. Ms. Morris was 100% aware of the hearing.
If we're speaking on things, I'm sorry, my phone blanked out. If that may have been, I did file 2 motions. So I don't know if both of them actually came through. I can't pull up the ones that I have and I can send it back into the court.
Ma'am, so I have your signature on a motion to set aside the default. And under paragraph 2, you're asking the court to set aside the judgment. And it indicates that it must be filed within 10 days of the default judgment. And then it's because, and you wrote in, I was unaware of the hearing, and it's only after 10 days because of the holiday. The first part of that is it's patently false. You were aware of the hearing because you filed the request for a Zoom on that, so you knew the hearing was taking place. And then you said it's after 10 days because of the holiday. I don't even get that because the judgment was on November 18th, and there's at least really 7 days, well, more than 7 days before the holiday. There was like 9 days before the holiday that you could have filed it. So,
and I'm confused on the motion.
It did not get filed with us until December 1st was your signature, and that's when our timestamp is.
And yes, I do. I'm not trying to cut you off. I did call in. She did let me know that I had a few more days, and she let me know that I had to file a motion. I have the emails from you guys, and I never got the $20, I guess the check thing to actually put the motion in online. So I had to have someone come up there and do it. I would have had the motion in prior to that. My Zoom hearing was denied, and I did submit a piece of paper with a lengthy information on what we're talking about. This is the same conversation that we had prior to when the other attorney decided that they needed to train staff and we're trying to come to a resolve. So my information hasn't changed. And my issue hasn't changed either. And if we would have been in court in May, because that ledger says I had a balance.
Ma'am, trying to go back to May, Ms. Dornbush just stated you had a credit on your account, and that's why they dismissed it.
Correct. The same day, Judge. Ms. Dornbush is not acknowledging that her client put a non-sufficient funds fee and reversed that payment back onto my ledger after I spoke with her.
When are you saying that happened?
That happened on the same day on 5/6 of 2025.
Do you see that on the account, Ms. Dornbush?
I do see that, Your Honor, and I believe I can't speak to it with certainty because I was unaware of that until Ms. Morris brought that up. But if a dismissal had already been submitted to the court, my client would have then had to motion the court to reinstate the case, number one, to try to pursue those amounts. And following that, Ms. Morris did continue to make payments on the account in June, Payments were made and credits were done to the account, leaving a balance of $50.49. And so I don't believe my client felt there was a reason to reinstate based on subsequent payments being made.
Well, sorry, I don't want to cut you off. Just to let you know, Ms. Dornbush, because I know you didn't speak to your client. I spoke to them and we were going back and forth. They ignored my phone calls, a whole lot of things. That was done probably about 2 hours after me and you had spoke. And they literally have it on the ledger. They knew about it, and it took over 30 days for them to actually correct that. And they also put a $30 late fee onto May's rent as well. So this is an issue that needed to be addressed because just like with the $2, my rent was supposed to go up in August. That's a whole 12 months. So I understand that
what is her current balance?
The current balance, Your Honor, hold on. I've got to find the current ledger that I have for this case. Give me just one moment. With December, Your Honor, $2,364.19.
And ma'am, if I take everything that you're saying, how much are you saying you owe?
Honestly, Judge, there was a discrepancy.
This is the judge doing what judges do, forcing the case into a simple box that can be ruled on. What's the current balance? How much do you think you owe? Those are the make or break questions. The landlord's side says one number. The tenant says it should be closer to a few hundred, and then the judge tries to reconcile it like a math problem. Escrow payments, late fees, and alleged discrepancies. And notice, the judge isn't saying the tenant's complaints are impossible. The judge is saying the numbers aren't matching the claim of a 1,400 discrepancy. Courts can't grant relief based on a narrative alone. They need a coherent calculation. That's why the judge keeps pressing. Where exactly does the missing amount come from? If you can't connect your story to a clear total, the judge can't justify overturning a default judgment that's already in place.
So you tell me, taking out all of that, how much do you think you owe right now?
I think I owe them around $300 from the discrepancy that the office made in September, sending out a notice, 7-day notice, saying that my rent was $360.
Did you pay December rent?
Yes, I did. I paid it into escrow at the court, and I did that with November's rent as well.
Okay, I've got $700. So you're saying that if I take that $700 off, add the $300, so basically $1,000, that you're saying that there's an error on your account in the amount of $1,364.19.
Yes, it is.
Absolutely not, Your
Honor. You can say absolutely not.
Where is that going to come from, ma'am?
So where it's coming from is my lease is supposed to start in August. They charged me a lease increase in May, June, and July. My lease is supposed to be from 8/1/2024 to.
All right. So in May, June, and July, what are you saying they charged?
They charged me $694 for lot rent.
And if you're saying that, what should it have been?
My lot rent should have been $657.
So that's about a $50 difference each of those months. That's $150.
On top of late fees.
So how many late fees?
They charge you 2 late fees per month.
Okay, so even if they did that,
per month.
And Ms. Dornbush, maximum amount of late fees per month is what?
Your Honor, the late fees total per month is $55 that gets charged on after the 5th, and $30 that gets charged on the 12th.
This part is actually fascinating because you're watching the judge test the claim in real time. The judge asks about the maximum late fees per month. Here's the numbers: 55 after the 5th and 30 after the 21st, and then immediately does the math. 85 times 4 equals 340. Then the judge adds the claimed rent rate difference and asks the obvious question. Even with that, we're not reaching the 1,300 discrepancy being claimed. That's courtroom logic at work. Judges will often take the best version of your argument and still ask, does it add up? Because if the math doesn't support the conclusion, the court can't rewrite reality. This is also where the tenant's argument starts collapsing under complexity. Portal lockouts, TIN fees, NSF charges, credits removed. It might all be true, but the judge is still asking for a single clean number trail. Without that, the court's hands are tied.
21st. So it's $85 a month. However, let me go look at Miss Morris's ledger and see if she's actually making these payments timely. Because if she's not making her payments timely, whether there's a discrepancy or not, the late fee would have hit. So
I hear you on that. But what I'm getting at is your numbers aren't matching, because even if I take 85, give me 85 times 3, give me 85 times 4.
5 times 4, 340.
340. So I've got 150 and 340. Where else are you claiming that there's a discrepancy of some type?
Okay, so moving forward, if you look at July, well, you took that. If you said my rent was $657 in July, I went into the office. They locked my mailbox, and I have been kicked out of the customer portal to pay online. So I get charged a $10 fee with every payment.
Ma'am, listen to me.
If you look on my ledger,
listen to me. You are claiming that there is some $1,300, almost $1,400. That is a discrepancy on your account. I'm asking you for where that discrepancy is.
Okay,
you
sir.
You are giving me 150. I'm not agreeing with you. I'm just saying,
Mm-hmm.
Where are you getting these numbers?
So where I'm getting these numbers from are my ledger. It started in May. So they put a non-sufficient funds fee on the account. After they put that non-sufficient funds fee, they added that money that was owed for May, the rent, they added that onto June. I have a 7-day notice from June. It says my rent at the top of the paper is $657, but they're not putting that onto the ledger. So that is incurring a balance. They put the non-sufficient funds fee, put the 718 back onto my ledger around June 12th or June 13th. Moving forward, we still had a balance in July. No one is trying to come to an agreement about the balance with my ledger. So it kept on incurring. Then we get to August. I go into the office. They say I owe $175. So she says, well, you know what? Since you've been locked out of your account, her name is Dana. She said, you've been locked out of your account. We'll credit you those $10 fees back. I'll do 17 of them. We're going to investigate. We'll do more. Kenya just took those $170 credits off in October. Those were supposed to be taken off in August. I paid my October rent to the office. They told the court that they didn't have any rent. If you look at 9/6 on my 7-day notice, Kenya, the new manager, sent out a letter saying I owe $360.
Ma'am, you are telling me that there's some $1,300, $1,400. You are not telling me where those numbers are coming from. You have given me a total amount of $490, basically, that you're saying shouldn't be on your account.
I said there's a total, the $450, if you look at my ledger that I paid in September, that was supposed to be the total balance owing for September. That was a staff error. It was $360. I made a $450 payment to cover the late fees. So I should not have a balance. That was a staff error, not my fault. They sent me one paper in the mail and they sent another paper to the court. They also tried to steal my money order. I also submitted to the court the payments that are made on their check system. My money order from May is not in that check system. Kenya, the manager, asked me, well, did they actually input it back into the check system? I said, I don't know. So I asked her, could I have proof? So all of this, my account is screwed up since May because of these different charges. They're saying I owe $2,000, but they also charged me a late fee and my rent was in escrow. In November, my rent was paid to the office. The only time my rent was short was in September of 2025. And that was a staff office error. That was not a tenant error. I paid what they said was owed. Then they turn around the same day and send the court the same paper with different numbers on it. That's not my fault. All of their information that they even sent into the court with my lot rent. Sometimes it's $266, sometimes it's $391. And Rachel Dornbus, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was
All right,
supposed to start in August.
ma'am, here's the problem. Problem is, your motion says none of this.
Is that my motion? A motion?
And here's the procedural dagger. Your motion says none of this. That's the judge explaining the fundamental problem. Even if every ledger complaint is legitimate, even if the tenant has receipts, even if the landlord made mistakes, the motion in front of the court doesn't lay out those arguments. Courts don't love being ambushed with new issues at a hearing, especially when the other side prepared to argue the written motion. A motion to set aside default is not a free-for-all. It has to clearly state the grounds and provide the reasoning. The judge is basically saying, "You're asking me to undo a judgment, but you didn't properly present these claims in your filing, and you also included a statement that contradicts the evidence." That combination is lethal, procedural weakness plus credibility damage. And when the judge says, "I'm about done," that's not a threat. That's a warning that the ruling is already forming.
That I did, or did someone else do that?
I don't know.
Because I can send it back in. I can send proof back in.
Ma'am, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is, how does it not make sense for me, but it makes sense from the attorney? You're being biased.
I'm done. You're not going to interrupt me.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry,
denied.
I was never trying to interrupt you. You're very biased.
Thank you.
You're very biased and disrespectful.
I'm done.
It doesn't matter. You're disrespectful and you're very biased. You need to do your job. You don't know how to do your job.
That's all. I am done. Motion denied.
Your Honor, I would request that the money's held in escrow. I think, Your Honor.
The money's held in escrow are released to plaintiff and will be applied to the account balance.
Thank you, Your Honor.
You have an attorney. You have a boss as well. You're very biased, rude, and disrespectful.
Mute her and kick her out of the meeting.
This is where emotion completely overtakes strategy. The judge is asking for figures and procedural clarity, and the response becomes accusations. You're biased. You don't know how to do your job. You're rude. The problem is, in a court setting, attacking the judge personally almost never helps your legal position. It usually confirms the judge's concerns about control, cooperation, and credibility. And watch the court's response. Motion denied. Clean. Immediate. Once the judge has enough legal reason, false statement in the motion, timeline issues, failure to support the claim properly, the door closes. Then the plaintiff's attorney requests that escrow funds be released and applied to the balance. That's a practical consequence. Money being held gets directed to satisfy what the court recognizes as owed. This is a classic courtroom lesson. The fastest way to lose ground is to ignore the question being asked and fight a different battle out loud.